My name is Symone Asah, and I am a community manager at Nairobi Garage in Karen. For those of you who are not familiar, Nairobi Garage is a co-working space, the largest and coolest co-working space in Nairobi. We have 4 locations across Nairobi, and we believe that co-working drives innovation because whenever people share physical spaces, they are able to collaborate to create things they wouldn't have on their own. So we have flexible spaces in Nairobi, and they give you and your business a space to grow and to get connected to large networks of similar-minded professionals so that you can increase your impact and your scale. We have a network of 1,000 plus entrepreneurs. We have a home of over 150 growth-focused innovative businesses, and we have weekly networking events and sessions that we host. This workshop is one of those. We have 4 locations across Nairobi, Karen, where we are currently located, Kilimani, Spring Valley, and Westlands. Our spaces do have a variety of amenities that you can enjoy, from fully furnished offices to breakout spaces, bottomless tea and coffee to keep you alert, and unlimited access across all of our spaces, of course, reliable internet. We also do have some member benefits that you get to enjoy from a network pool of 1,000 plus entrepreneurs to networking events like this, where you can engage with the business ecosystem in Nairobi. This is just a picture of some of our spaces, some of the offerings that we have, a variety of flexible workspace options for you, our 4 locations across Nairobi, and how you can get in touch with us. So today we are privileged to host Sisule Musungu, who is the managing partner and team leader for intellectual property at Sisule & Associates. He'll be taking us through a session on how to leverage intellectual property strategies for business growth. Sisule is actually an international IP expert. He's spoken about this in countless forums across 35 countries across the globe. So you are in good hands today. I will hand over to his colleague Mutua Mutuku to do the moderating for the session in a minute. But for now, allow me to just let you know that you can drop your comments in the chat section. You can introduce yourself in the chat section. Put all your questions in the questions tab, which is separate from the chat section. We will also have a poll that will be going. You can access this there and participate, and just engage with us. So karibu sana everybody, and enjoy. Over to you, Mutua.
Yeah. Thank you, Symone. Hi, everyone. Mark, Munera, Edwin, Omboy, Trish, and Dave. I believe you can hear me now and you can see us. Apologies for the breakdown in sound. My name is Mutua Mutuku. I'm an advocate of the High Court of Kenya, and I'm a patent agent. And today we have the honor and privilege of having Mr. Sisule Musungu, who's a legal practitioner. He's done this for over 20 years. And he'll take us through the process of intellectual property. He'll tell us what this animal we hear being mentioned, what is this thing we call IP. And for everyone who's asking the slides, whether we are going to share the slides, yes, you're going to share the slides in the emails. So for today, we just want you to sit down, listen, enjoy, ask questions. Whatever there are polls, you just vote, and we go on this journey with Mr. Musungu. Mr. Musungu, welcome.
Good morning, everyone. I hope you can hear me as well. Thank you for joining us. And let me begin by apologizing. This event was to happen last month, but we had an unforeseen scheduling problem, but we are glad that we are here today. I would like to talk about intellectual property and how you can leverage it for business growth. While I'm an advocate, I'll not be too legalistic. I'll try to connect law and practice so that we can all go together. So I will start. I will start with a short introduction and overview. I would like, just for our purposes today, to indicate what intellectual property means, but not go into too much details. So according to the World Intellectual Property Organization, WIPO, intellectual property are creations of the mind, which include inventions, literary and artistic work like music, photos, designs, car designs, other industrial designs, symbols, names, images that are used in commerce or in business. And in turn, intellectual property rights are the rights that the creators of these creations of the mind are given by the law, primarily to provide them exclusivity for the use of those creations. And that is where the word intellectual comes from. So intellect, intellectual property, as opposed to real property, or as it's known. So with that understanding, you can see that you can have a variety of intellectual property in one item. So the image you see, you can see that there is a trademark. The sole of the shoe has a patent. The aesthetics or ornamental look is a design, and the actual photo is a copyright. So as you think about intellectual property, don't think about one item, one intellectual property. It could have multiple rights, and in some cases, multiple creations. So for today, I want to talk about around 4 questions. The first question I would like to address is, how do you know what intellectual property you have and why would it matter? Secondly, how do you know the value of your intellectual property and why does it matter to know that the value of intellectual property that you have? Thirdly, how do you commercialize or monetize your intellectual property so that as we talk about rights, you can make something out of it? And finally, how do you access or benefit from intellectual property that might not be the US? So let's start with the first question. How do you know what intellectual property you have and why does it matter? There are 2 main strategies that you would use to determine what intellectual property you have. The first strategy is to do what we call intellectual property audit in your organization or in your company. And that essentially is a process that you would use to systematically review your intellectual property, what you have, what is owned by you, but also what intellectual property is being used by the business. There are cases where you are doing business, you don't own intellectual property, but you are using other intellectual property from other people. And an IP audit would give you that information at a particular point in time. The second strategy would be internally developing your own intellectual property strategy or guidance for your staff or for your team. So what that means is that you create a framework within your organization for systematically identifying, registering, exploiting, and protecting your intellectual property. What that means is that with a strategy or guidance, you have a continuing way of identifying intellectual property as it's generated. So an IP audit gives you a picture at a particular time, while an IP strategy or guidance is now your continuous process that enables you to continuously identify new intellectual property that you either have or are using from others. So why does it matter? Why does it matter that you know the intellectual property you have, either at a particular point in time or as a continuous process? First, it matters because you need to know if your intellectual property, if you have it, if it's registered or not, when it expires. In most cases, intellectual property expires. For example, patents for 20 years. You need to know if it needs renewal. So for example, trademarks are in most cases for 10 years, but they are renewable continuously. So if you do not know, you do not know when the registration happened, when renewal is required, you will find that you lost, you have a trademark or a brand whose protection you lost because you didn't have a process internally to make sure that you take care of these things. Secondly, it matters to know the IP you have to avoid infringement of other people's rights. So when, as I said, when you do an IP audit, you are not just checking the intellectual property you own, you're also checking the intellectual property that you are using in your business. So if it's a third party's intellectual property, that audit would tell you that you need to be clear whether you are allowed to use that third party's intellectual property or not, or if, how do you acquire the rights to use it? So it's very critical that you understand what you have and what you are using to avoid infringement and the attendant risks, such as litigation. Thirdly, it matters because you need to know what is being used and what is not being used. So you might have intellectual property, but you are not using it because it doesn't fall within your core business, or at that particular time you don't need to use it. And that knowledge would help you, for example, decide that because I'm not using this particular intellectual property and I'm not benefiting from it, why don't I license it to a third party who can be able to use it and they'll pay me royalties? So you will monetize it that way. But if you don't know what you are not using, you will not be able to make those strategic decisions. And that goes to the fourth point, which is that knowing what you have ensures that you have a strategy on how to exploit each of your IP assets at any particular time. I'll move to the next question, which is, how do you know the value of your intellectual property and why does it matter? So in order for you to leverage your intellectual property, once you know what you have through an IP audit and continuous an IP strategy, the next step is knowing the value of your IP. Because I think you cannot leverage if you do not know what it's worth. So valuation of intellectual property is a specialized form of activity, but it happens. So I'll just mention the main methods of valuation of intellectual property. There is the first method that is used in valuing intellectual property is called the cost method. So the cost method essentially means that you assign a value to the intellectual property based on the cost of creating the intellectual property or a similar intellectual property. So that is the cost method. That is the value you will give it. The second method is the income method, where through gathering information and projections, you would assign a value based on the income that is expected to be generated by that intellectual property. So that is the second method, the income method. The third method is what is in literature is referred to as market or economic method, which essentially means that you would assign a value to the intellectual property based on a similar transaction of a similar intellectual property and what the cost, what the value was in that transaction. So it requires quite a bit of market intelligence and information, but that's another way of valuing your intellectual property depending on what it is. So why does it matter for you to value your intellectual property? It is property and therefore it is exchangeable. And so in business, you need to know the value for a variety of reasons. The first reason you want to know the value of your intellectual property is if you want to sell it or auction it. So you can sell to a particular individual directly, your intellectual property, or you can auction it. So in an auction, the value you have would give you an indication of what is the minimum price you are looking for. So that is one of the reasons that you need to know the value of your intellectual property. The second reason is in the context of licensing and franchising. So if you want to license out your intellectual property, as I said earlier, you might have intellectual property that you are not using and you want to license it out. So you need to know its value so that you can know the royalty you will charge for that. It would happen in cases of franchising as well, where if you know the value, if your trademark is being used in franchising, you would know the value to charge the person who is getting the franchise and over what period of time. So that is the second reason that it's important to know the value of your intellectual property. The third reason is in the context of litigation. So someone has infringed your intellectual property, you have gone to court, and this happens very often. People go to court and say, X has infringed my intellectual property. They actually prove that infringement happened. But when it gets to the end, so what is the value? How much should you be paid in damages? A lot of people have no answer to that question because they don't know the value of the IP. And you can't just come up with a figure from the air and tell the judge, I want X million. You have to prove that that is actually a reasonable value of what has happened. So in calculating damages, when you are going to court to sue someone who you think has infringed, you need to have a value as to if it's true they infringe your intellectual property, what are they supposed to pay in damages? Because if you don't give that information to the court will probably give you general damages as opposed to specific damages which are calculated because of the loss you've suffered. Fourth, the fourth reason that one wants to know the value of intellectual property is in the context of mergers and acquisitions, in bankruptcies, in insolvency. So in mergers and acquisitions, as you calculate the assets of the different companies that are coming together, or that is a company that is being acquired, the value of intellectual property needs to be known so that it's part of the calculation of the costs or what is to be paid in that transaction. It also matters in bankruptcies because it's an asset that needs to be known how much its value is, and in insolvency. So when you are calculating the values for that business that is going under or is being wound up, you need to include a value for the intellectual property that is owned by that company. And finally, knowing the value is also critical for your decision making in terms of your exploitation strategy. So if the value is quite significant and you are capable, you might want to directly exploit the intellectual property yourself because you will gain maximum benefit. But if the value is different, you might consider that it's better for you or more strategic for you to license out or to sell that intellectual property and get the value in that way. So I think that's another reason that is critical to know the value of your intellectual property. I think just so that we get some interaction, I will break here for some Q&A and clarification so that, and then I'll go back to the remaining 2 questions.
Ladies and gentlemen, that was not Mr. Mutuku, that was Mr. Sisule. Let me clarify that. Now, just a few questions here. I have seen that our good friend Symone Manambo was logged in for the meeting. Thank you, Symone. Now, Victor Kenneth asks, where do I patent a software app? How much will it cost me? That is one. One gentleman by the name of Mark Mackenzie, pardon?
What was the name of the first?
It's Victor Kenneth.
Okay.
And Mark Mackenzie asks, is the topic centered on the African region? Then he says Jackie Nankinga. Oh, that's Jackie Nankinga who asked that from LinkedIn. And there's another person by the name of Trish Muchembi. I think it's a follow-up question from what Victor had said, and is asking, does the type of software determine the cost?
Okay.
There's another question. I don't know if you take that first, then you can take it. Yes, please.
Okay. Thank you, everyone, for the questions. To Victor's question, where do I patent a software and how much does it cost? Just to step back a little, in most cases, software is not patented. There are countries where you can patent software, such as the United States, but in many countries, software is treated as copyright. So the code is copyrighted, and it is copyrighted the moment you fix that code, you write the code. You would get, in many cases, automatic protection, because in case of copyright, you do not necessarily have to register it. You just, but you can, as an option, register it. The costing would depend on a bit of detail, so I can't give you a figure. It would depend, there will be some analysis to determine what exactly it is, what does it do, to determine what the cost would be if you want to register it as an option. So for example, in Kenya, once you write the code, you have automatic protection, but you have the option of additionally registering it. To the question by, you said, Jackie Nakinga, if the topic is Africa-centered, intellectual property is a question around the world. So, for example, the World Intellectual Property Organization has over about 180 country members, including most of the African countries. So this is, I think, a general topic, not just for Africa, but for our purposes. Of course, we are in Kenya and we are in Africa, so it's relevant in that context. Trish Mushemi, yes, the question as to the type of software, if it determines the cost, yes. And that's what I said earlier, it will depend on some analysis of what we are dealing with and what exactly you are looking to achieve, whether it is simply you want to understand the protection and optionally register, and what are you dealing with, one country or several countries. Thank you.
Mr. Sisule, Victor is not letting you go off that easily. He's asking, he's building on Victor Kenneth's question. He's asking, is it possible to patent a specific algorithm as opposed to the entire software?
Yes. It is possible, and that's why I said, depending on the technical, what exactly it is, there are certain features that can be patented. There are certain countries that generally are resistant to patenting software as such, but wherever it is possible, yes, it is possible.
And Maurice Grace Utetiwabo, I hope I got the name right. She's asking, what's the difference between franchising and licensing of intellectual property?
It is, thank you. Grace.
Yes, Grace.
Grace, yes. It is interlinked in a sense. Licensing is a general term in terms of assigning, allowing someone else to use your intellectual property under particular conditions and a contract. Franchising goes beyond the licensing of the intellectual property, so that in franchising you will have, yes, the intellectual property like the trademark will be licensed to you, but the franchise goes further into processes, business processes themselves on how things are done. So a McDonald's, you will have the trademark license to you, but you will also acquire business processes of how do you make a burger in a particular way with particular ingredients and all that. So that is the distinction. Within franchising, there is licensing, but franchising is a broader concept that includes intellectual property and more broadly business processes that are involved.
Well, questions are coming thick and fast. Evil is asking, enforcing intellectual property can be costly. Is it worth creating IP rights if the company cannot afford to sue others?
Thank you for that. Yes, enforcement can be costly and protracted, as I indicated earlier in litigation context. So it is worth creating, even if you cannot, enforce or afford the costs. And that is why I mentioned earlier that once you know what you have, if you discover you have created X intellectual property, but you are not able to enforce it, and I'll come back to this topic a bit later, then you make decisions strategically, should you license it out or sell it to someone who can be able to enforce. So you will extract your value by the sale, but you have sold it to someone who can enforce it. So it is a matter of strategy. Once you create, you know it, you know the value. If you think the costs of enforcement are too high, then what you do is you strategically make a decision whether you will sell it or license it, and the person who you license it to, for example, will be able to enforce it. But I'll come back to that topic in the context, particularly of copyright, on other strategies that you can use to be able to enforce your intellectual property, although individually you might not be able to afford the cost.
And now we have a good friend.
We have a good friend called Timothy Odera. And I think we can take at least 3 questions because they're coming. There are quite a number of questions. We can just take 3, and then we continue the presentation. As more questions are coming, we keep on. We keep going, because if we keep taking one now, we'll take forever to complete the presentation. Now, Timothy Odera is asking, what is a suggested method of valuing music works as a type of intellectual property? What is a suggested method of valuing music works artworks as a type of intellectual property. And he says, any other comments on music as well? Victor is asking, can I get a rough estimate of the price, the least I can pay? I think with regard to yes, the first one. And then our good friend Simon Manambo. Hi Simon. Asking, have you ever encountered double patents, either by mistake or circumstances? And how is it resolved? I think we'll take three first, then you can continue the presentation, and then we'll keep on taking more questions.
To the question by Odera about valuation of music, the method, I think, and I should mention that this valuation methodologies could be combined. It doesn't have to be one. So for music, the market method and income method would probably, a mixture of that would give you the best valuation. The cost method for music, especially in this age of technology, might not be the best because the cost might be has reduced because of technology, so you might not get a good value from that method. But I think the market method and income method would give you the best valuation for music. For Victor, it's really, I think I will have to follow up with you offline to understand what exactly we are dealing with, because I'll be giving you a ballpark figure that might not make sense at this point, because I am not sure about exactly what we are talking about, the exact IP that we are talking about. So allow me to follow up offline with you to get some understanding and then be able to give you some information. For Simon Manambo, double patent, I'm not sure if I fully understand the question, but there are many cases where you have overlapping patents. And what I mean is that you have a patent which for you to exploit, you will require another patent. So what happens is in such a cases where you cannot implement your patent because there's an overlapping patent, what happens is you can cross-license between the two players, that you will allow each of you to use the other's patents because you need it to be able to use yours. I should also mention that in a single product, for example, you can have many patents, many patents, and in some technical products, hundreds of patents could be involved in a single gadget, or a range of intellectual property could be involved in a single gadget, and we have a process that is called patent landscaping, that is used to map the landscape around a product. So you map what patents are involved around that product, and it will show you the interlinkages, which patents you must have to be able to operate. I think I'll stop there. We can go back to the presentation. Then we can take, I think, more questions at the end.
Just before we get back to the presentation, there are few comments in the chat. We have one Victor Kenneth saying, this is interesting. Eve M thanks you for the response to the question. Trish Mushemi says this is quite priceless information. We can go back to the presentation.
Okay, thank you. The third question that I had indicated I will talk about or try to answer is, how do you commercialize or monetize your intellectual property? So essentially, from based on the presentation, you have audited your intellectual property, you have registered what needs to be registered, you know the value of that intellectual property. How do you turn that knowledge into capital or cash? It's not just automatic. And I think the question that was asked earlier regarding, there was a question earlier that I think is relevant in terms of you create intellectual property and you can't enforce. So what is it for? So there are different ways in which you can monetize your intellectual property, but as you think about monetization, there are a few factors that I would like to point out you need to take into account. The first factor is the capability of the individual of business, and that is actually that question. Or do you have the capability to yourself directly exploit the intellectual property, or you don't? And if you don't, then there are different considerations. The second factor to consider is the market structure, the market in which you are operating, including the regulatory framework that you are operating within. What rights do you have in actual fact? And it's important to always remember that the extent of your rights are not exactly the same in all the countries. In each country, the law will vary, and the extent of your rights or what you can or cannot do will depend on that. So if you are operating in multiple markets, you have to have that understanding. The third factor you have to consider is the capital required to exploit the intellectual property and the ability to access such capital. Do you have it yourself, or do you need to borrow? Can you use that intellectual property as collateral or not? Or do you need that capital from someone else that has the capital? So it's a factor to consider. The other factor to consider is the overall portfolio of your intellectual property vis-a-vis your core business of the organization. So if you have intellectual property that is important but is not critically relevant to your core business, it's a factor you need to consider before determining how you commercialize or monetize your intellectual property. So there are a few ways that I would like to talk about in which you can monetize or commercialize your intellectual property. The first one is the obvious one in terms of in-house use to generate revenue. So you have the intellectual property. If it's a patent, you produce the product and sell it, or you directly use your software and sell it to people, or have people license it, whichever way you prefer. You can sell directly the intellectual property, or what we call assignment. So you sell it and you are paid a one-off for the value of that intellectual property, and you would have monetized that particular asset. You can also commercialize or monetize in the context of licensing and franchising. As I indicated, you would license out the intellectual property and people would pay you royalties. It would be the same in the context of franchising. So if you do not need to, either because the intellectual property is not directly in line with your core business, or you don't have the resources to exploit it, what you would do then is to license it and monetize that way. If you have a powerful trademark and you do not want, or you are not capable of going to so many markets yourself, then you would franchise. In that sense, you will be able to get into more markets than you would otherwise yourself do. You can also monetize in the context of mergers and acquisition, or in context of joint venture, in the sense that you might need either to exploit that intellectual property, you need other intellectual property rights, or you need capital which you do not have, and you cannot access that capital as yourself. So what you would do is find a business partner who either you would merge with, or they could acquire you, or it could be a joint venture, which would then give you the capabilities and resources to exploit your intellectual property in that sense, and do it's ways in which you can get money out of what your intellectual property is. The last strategy to monetize that I want to talk about, and I mentioned earlier, is collective management, which applies primarily in the area of copyright. So, for example, you are a musician, you have a song or an album, and all radio stations are playing it. It's on ringtones and all manner of places. It's being played in public places, restaurants, bars, and all that. It is very costly for you to individually engage each of these players and to license them and agree on terms and all that. So one way to commercialize or monetize your IP is to go through what we call collective management organizations. These are organizations that would administer the rights on your behalf, on behalf of a large group of people. And so they would have one license, they would license out to for example, radio stations. They would collect the royalties and distribute the royalties. So that reduces your cost of engagement or enforcement, and it would help you be able to get money in places you would otherwise not be able to get, because you just don't have the resources to engage everyone. Collective management also helps you create market power. So if you are an individual musician negotiating with a radio station, Capital FM, or negotiating with Safaricom, your market power is relatively diminished. But if you have a collective management organization that has resources, because there's an administrative fee that they get and are able to use, then you will be able to get better royalties, for example, than you would otherwise get if you went as an individual. So collective management is also a way in the copyright space that you can use to monetize your intellectual property. And then, so we go to the final question, which was, how do you access or use intellectual property that is not yours? I say there, do not reinvent the wheel. So there's a lot of information about intellectual property that is held out there. And we have a range of intellectual property databases, particularly for patents, designs, trademarks, and copyright. So before you do anything, it is of benefit to look at these databases, because they tell you what exists, what is owned by different people. And in an area like patents or design, we usually, the way knowledge grows is that patents that are being applied for now, that technology will probably be used in 10 years time, not right away. So if you are developing an invention, it would be of great benefit to you to check out the databases. Where has the technology reached, or where has knowledge in this field reached? And that is essentially because part of what we call the social contract, taxpayers have to pay and the government has to protect protect your rights. Part of the bargain in areas such as patents or design is that after a certain period of time, the applications are published publicly, so that people can see the information, and also to the maxim that you stand on the shoulders of giants, in the sense that you can be able to build from what is known, instead of you going back to think about things. So we have public and free intellectual property databases. So for example, we have WIPO, the World Intellectual Property Organization, has what we call PatentScope, which contains a lot of information about patents that have been applied for, either through the WIPO systems or through countries, and you can search using a combination of methods. And you should not be afraid to do that because of something like language, for example. The system can translate for you. So if the original application was in Chinese, the system will translate for you. You can get a translation of what exactly it is. There are other regional ones, like the European Patent Office has a SpaceNet. Many national offices have fairly good databases, especially the major industrialized countries, the US, Japan, Australia. They all have various databases that you can search and see what is there. You have, though private but free, for example, Google Patents would give you also a lot of information, millions of patents that are published and can be translated. There are also private commercial databases that are more detailed and give more information, and you pay for them. So there are things like Microsoft, LexisNexis IP that you can also use at a cost to mine data and understand the landscape in which you are operating in terms of the various intellectual property rights. Of course, you can access and use IP that is not yours by buying it. If you think you need it, or you need it to be able to exploit your own intellectual property, you could directly buy the intellectual property from whoever owns it, if you agree on the cost. Thirdly, you can also leverage or access IP that is not yours through leveraging what in law are called exceptions. In most countries, you have various exceptions to the general rule, which is that the owner of intellectual property has exclusivity. So there are various exceptions across the different laws that allow a third party to use, in certain circumstances, another person's IP without their consent and without paying for it. So, for example, in the area of patent, we have in many countries what we call experimental use or research exemption. What that means is that when you use a patent for purposes purely of research or experimentation, you do not need permission or consent, because you are not commercially gaining from it. And it goes back to the point that part of the idea of protecting patents for a period of time is to encourage growth of knowledge. So if you are testing out a patent that exists to see how it works, if it works, or to build on it, and it's purely for research and experimentation, you do not pay. In areas such as copyright, you have, for example, what we call educational use for books, where if you are using information purely for instruction without any further commercial use, you are allowed to use it without permission. So across the different types of intellectual property, there are different exceptions that you can leverage on to access intellectual property that is not yours. And of course, Similarly, just the same way that you can license out your intellectual property, you can also access other people's intellectual property by licensing from them and agreeing on the terms in which you will operate. And finally, also you could do a joint venture to access IP that is not yours, so that you jointly exploit it with someone who has similar or interlinked intellectual property for both of you to benefit. I think that would be primarily it, and we could return to the questions.
You see, even as you moderate, you also have a few questions. On your last slide, you talked about how to access and use IP that is not yours, and you gave out certain examples. You talked about availability of it for educational purposes. Is that what lawyers call fair dealing and fair use?
No. Fair dealing and fair use is different from educational use. Fair use is in copyright, for example. When you quote someone else, it is their work, but you are quoting it in your work. That means you are using their work, but in the general context and understanding, it's fair use, that you are not, for example, taking a very large extract of their work. You are only taking a limited extract to explain something else. So that generally that's what you would probably be dealing with, as opposed to educational use, which applies in the context of classroom instructions and using, for example, textbook and all that.
Thank you for that. Now, there are a number of questions that have come. I think our friend Trish Mushemi has a software somewhere, and I think they need to either patent it or copyright it. I think you guys should have a conversation. But then they're asking, when it comes to either patenting or copyrighting a software, you give them a range of, I think, the amount of money that is the maximum to the minimum. They also think about the timelines. Okay. That's Trish Mushemi. Victor Wangi. I hope this is Victor, the artist, the who draws. Anyway, Victor is asking, if I have a patent or copyright registered in Kenya, in how many other countries can I enforce it?
That was Mwangi.
Yes, that's Victor Wangi.
Okay.
And then Mark Mackenzie is asking, as an artist, if my artwork is used internationally, how can I monetize it on a global basis? And we have a question from Victor Kenneth.
Sorry, the last one was
Mark Mackenzie.
Yeah.
Is asking, as an artist, if my artwork is used internationally, how can I monetize it on a global basis? That's a question that came from LinkedIn.
Okay.
We also have a Victor Kenneth asking, in Kenya, is Kipi responsible for all things patent? And you can take those ones. Yes.
Trish Mushemi, it's the same question I think Victor was raising earlier, the costing. There are a few variables that one has to understand, and I would be very happy to offline give you some information once I understand certain variables. So there are variables like if it's a patent, do you have all the information, drawings, or everything already done? If you do, your cost will primarily be the legal cost of application and all that. If you don't have, if it's a patent, the drawings, the description, and all the paperwork done, it means that has to be done. And in some cases, it has to be done by technical people. So it means there will be a cost for having that done. So it will change. The other variables, like in how many countries are you imagining you want protection? As I said, intellectual property is primarily, except in a few cases, it is country by country. So how many countries do you want to protect the rights? And that will determine the cost. So if I get a bit more understanding of what you have, I can be able to give you some basic information as to what you are looking at in costing terms. Victor Mwangi, if you've registered in Kenya an intellectual property, how many other countries can you enforce it in? Only Kenya. But it comes with a but. There are certain, for certain categories of rights, like patents and trademarks and designs, there are certain international systems that you can use to get protection in multiple jurisdictions by making one application. So what happens, for example, is you would make one application through the WIPO systems. There are several systems for patent, for designs and trademark. And you would designate, or you would indicate which countries you would like protection. A certain amount of work will be done in terms of assessing the application up to a certain point, and that reduces your initial costs. But in most cases, at the very end, you would have to do an actual follow-up in the country itself. So if you've only registered in Kenya, the protection only applies in Kenya, not globally. But there are systems, including regional ones, at least for patents and trademarks in Africa through the African Regional Intellectual Property Organization and the counterpart in West Africa, that you can use to gain protection in multiple jurisdictions. The question from LinkedIn, the works are used across the globe. It's kind of related to the last questions, that you would have to follow through and understand the different laws and whether you are protected or not, or whether you need to make an application or not. So you would have to do some assessment of which particular countries are you interested in, and what are the legal requirements for you to get protection.
Now, Victor Kenya asks, in Kenya, is KIPI responsible for all things patent?
Oh, yes, there was that. Victor Kenneth. Yes, in Kenya, the Kenya Industrial Property Institute is responsible for everything patents, and not just patents, for everything trademarks and for everything designs. And in terms of patents, in Kenya and a few other jurisdictions, there is patents and what we call utility models. Now, utility models are inventions that do not meet all the requirements to be patented, but they are still an improvement on the existing knowledge in the country. So in Kenya, if you can show that you have done an invention that has improved technology, but it might not meet the requirements of patents, because the requirements for patents are very stringent, and the requirement, for example, is that it should be new across the world. It has to be new to the world, the whole world, not just in the country. So in Kenya, for example, we have utility models. Again, KIPI is responsible for that. Then you have, of course, the counterpart for copyright. You have KECOBO, the Kenya Copyright Board.
Timothy Odera, thanks you for answering our question on music. I asked you to follow up to that. Who can assist in the evaluation of music works? Can you know from help? Or who can I be directed to?
Okay. Yes, there are a range of experts who do this. as part of their primary work. We can do part of it, but we would have to collaborate with these experts. We can identify them for you, and you can deal with them directly, or we can work with them to get you the result you are looking for.
Could you please go further and outline the advantages of especially licensing and franchising as the best way to take advantage of collateralization under MPSRA?
What is that?
I have no idea what that is. However, I think we've got the first bit of the question,
Yes.
so we can go ahead and get run with that.
I think, as I explained earlier, there are various reasons why licensing is useful and important in terms of exploiting your intellectual property. So to start with, as I said, you could own intellectual property that is not part of your core business, but is valuable. So the best way, instead of spending time trying to create a new business line or new business processes, you license it to someone who already has systems to exploit. And that would allow you to better monetize. The same goes in terms of franchising. You might not have the capital to be in so many spaces, for example, or many countries. So instead of you looking for money to be in 50 countries yourself, you would license, or in case of, or franchise in that sense, so that you are able to reach a bigger market that you would otherwise reach with your own resources or capital. And different markets have different conditions and processes, including regulatory processes. So it might be to your advantage to work with a local, if you are going to a third country, with a local business that you will license, who are better suited to exploit the intellectual property in that market because they have local knowledge, they understand the regulatory framework, and they can run the process. So if you go in directly, your costs will be higher. You might even fail because you have no local knowledge. But if you license, you have a bigger reach and more possibility of succeeding. So those are some of the advantages why licensing is useful. As I said, licensing in the context of things like patents might also be key, because for you to exploit your own patent, you might need a set of other patents that you do not have. So licensing would help you be able to acquire what you don't have to be able to create a product and use your own patent.
The little bird says that the acronym MPSRA is Movable Property Securities Act.
So what was the question?
So it's asking the best way of licensing and franchising, taking advantage of that legal framework.
Okay.
Yes.
I have to think a bit about that one.
As you think about it, Ibrahim is asking, how much time does it take to grant a patent in Kenya?
How much time? It usually will take a few years. Usually the first 18, after application, examination, and all that process, the patent is published after 18 months, and then the final processes will happen. So within about, let's say 2 to 3 years, a patent would probably come out.
Sarah Amway asked, on franchising, does the franchisee have to register the franchisor's IP in a country before use?
Yes. So the way the franchising works, so if you own the trademark and you want to give a franchise to someone in Uganda, yes, you have to register the trademark in Uganda, it has to be enforceable in Uganda for you to be able to give it to give a franchise, because otherwise that person would not have exclusivity. So the first thing, wherever you are going, you have to register the mark first before you now give a franchise to someone together with other processes. And as I said, for franchising, it might be more than just the trademark. They might be business or other processes that are patented, for example, that would go together with the trademark. So even in that case, all those rights would also have to be registered.
Our friend Victor Ken says, he says the email keep it in January, inquiring about the information that you're sharing today.
Yes.
And they've never gotten a response. Telling you, if you could talk to your friends there, tell them, but you'll be responsive. Go ahead. Maybe we can go back to the Sudi question on collateralization with regards to the Movable Property Securities Act.
What
the best way? Is it franchising? Is it licensing?
I
Can
think
you get a collateral out of it as a creative? I think that's the more direct line of it.
I think you would licensing would be the way to go, because essentially franchising would not probably apply in that context, because franchising is a different process, as I explained. So licensing would be the best way to do that in that context. There was Kippy and responsiveness. I am sorry about your experience, Victor, but I'll mention to those I know there that they need to be more responsive, and January is very far off. I think if you are applying for a trademark, for example, if your interest was in a trademark, you would have gotten one already. If it's a patent, at least 6 months would have gone that you would have benefited from. So you wouldn't wait for as long as you would have to if you start now. But I hope that we will see improvements as time goes on. And I think as more people get interested in intellectual property and ask these questions, our institutions will also have to improve how they work.
Which ones to follow up on his question on the time? You know the time it takes for you to register patent, the 18 months, and then developing an additional number of years. So there's a follow-up question and asking, once the process begins, does that mean the IP can be reinvented and patented, copyrighted by someone else, or is it already protected, despite it and can receive the patent copyright?
Okay.
Yes.
For purposes, I think the question is most relevant in the context of patent or design. The moment you apply for a patent, you get what is called provisional protection. It's not the full protection because examination has not happened to determine that it qualifies, but you get provisional protection. So you can be able to prevent others from using it during that pendency period until you are either granted or denied the patent because it goes through a process. So the moment you apply, you get what we call priority. You get a priority, and there's a priority date. If you go, for example, to the databases I was referring to, like Patent Scope, you will see the application date and priority date. So that is the date in which, in many countries, provisional protection kicks in.
Yeah. So Victor Kenneth is telling everyone he's building a solution to the healthcare system in Kenya. And if you're not connected with him, it's high time that out of this conversation we go and connect on the thing and have a conversation, have a chat, and maybe people are going to be able to connect on so many other avenues and offer different solutions. I think from our end, we don't have many questions. We don't have any questions left. Okay. And maybe there's something we need to do before I go back to Nairobi Garage course. There's something we need to do at the introduction phase. We need to introduce the law firm Sisule and Associates. I think that was lost in the first introduction because we have sound. So we have a lovely lady here who's going to tell us who Sisule and Associates is. Come here.
Hi, my name is Cynthia Chebet, a legal assistant at Sisule and Associates Advocates. Sisule and Associates Advocates is one of the successor firms to the firm previously known as Sisule Muni Kilonzo and Associates, which was founded in 2009. The firm is a dynamic full-service law firm with both local and international experience, providing legal advisory services and litigation support to a wide range of clients. The firm boasts of a dynamic and versatile team of 10 members of staff who work tirelessly to ensure satisfaction of all our clients. We aim to offer practical, cost-effective, and timely legal solutions and advice. Good. Our practice areas include banking law, financial services and real estate practice, commercial and energy practice, contract management and procurement services practice, dispute resolution and litigation practice, and intellectual property practice. You can reach to us through our LinkedIn, which is Sisule and Associates, or Instagram, which is Sisule_law, or Twitter, which is Sisule_law as well. Or simply send us an email through info@sisule.com. Yeah, thank you. Yeah.
Hey. Thank you very much, Cynthia, for that. Thank you, everybody, for joining in today. We had quite an interactive session. I hope all of you have gained a lot. Thank you, Sisule, for taking us through this session and elaborating how and why it's important to value your IP and how we can go about monetizing them, and taking into account the business capabilities, the capital required, the marketing structure. We've definitely gained a lot of knowledge on how IPs can work to boost our business growth. So thank you so much for that. And thank you, Mutu, as well, for a wonderful moderation. I think we've all enjoyed this session quite a bit. Thank you to all the attendees that joined in, especially those that were actively engaged and asked a lot of questions. Thank you, Victor. Thank you, Trish. Thank you, Sarah. Thank you, Simon. In case I've missed anybody, thank you so much. We appreciate your engagement and we look forward to seeing you at our future workshops. So Sisule Law is actually extending 1 hour consultation to at least 20 people on all things intellectual property, specifically to the attendees of today's session. So if you would like to engage with them in this session, please look out for a link on how you can sign up on your email. The slots are limited, so the sooner you can jump on board, the better. They'll also be having an event next Friday on contract management in the digital age, which will actually be hosted by Sisule himself, as well as Wangeshi from his team and another team member. I will share the details on how you can sign up in the chat section. And we do have more workshops lined up from Nairobi Garage. We do have them every Tuesday, so please stay tuned. We share them on our LinkedIn page. I'll have that as well in the chat section so you can engage with us. Thank you so much, everybody. Please don't feel